Well, hello and good morning and welcome to Uncivil Law. For today's story, we are going to look at Nick Rekeita's motion to dismiss in his ongoing drug case. As you will recall, Nick Rekeita, otherwise known sometimes as the Law Pope, was found with about 26 grams of presumptive cocaine in his house, along with other things that might also be drugs. And there were some other problems relating to it. Plus, he's been in a issue with child services relating to his children, although I understand that that situation may have been mostly resolved, which, fair enough as far as it goes. Because, of course, that's a separate proceeding. Child custody is a completely separate matter. It's a civil matter involving different law, involving different considerations, and then a criminal case. So, whatever's happening there, fine. There can obviously be some cross information between the two. One can inform the other, but they're separate from each other. So that resolution, if it happened, then, fair as far as it goes. But obviously that doesn't inherently or necessarily impact the criminal proceeding, which we're going to discuss today. Nick Rekeita has moved to dismiss his case, to void the warrant, suppress evidence, and dismiss the charges for lack of probable cause. I have not read this document. We are going to read it together, and I will give you my first impressions of it. Of course, as I've already stated in other videos on this topic, I am skeptical of the motion to dismiss. You would expect it. And I would expect nothing less. And I have no problem with their attorney filing it. Their attorney should obviously file every possible defense that's available to them, that's available at law. And if there is a good faith basis to move for this, even if it's a fairly marginal one, then I have no problem with the attorney making the strategic call to file it. So I would expect nothing less, and that's fine. But we're going to try to assess its relative strengths. I'm not particularly optimistic because the standard for probable cause is very, very low. In a scale of 1 to 10, where let's say 9.5 or maybe 9.9 is the standard for conviction, like what is beyond a reasonable doubt on a scale of 1 to 10? 9.5, 9.9, maybe something like that, right? So on a scale of 1 to 10, where 9.5 or 9.9 represents the end of the road, and 5, by definition, is the standard in a typical civil case, preponderance of the evidence, then what would probable cause be on this scale? And I've often commented it's about 1 on a scale of 1 to 10. It doesn't take very much. So trying to find a lack of probable cause to suppress a warrant is tricky for 2 reasons. First of all, you have to show that there is no probable cause. And second, you have to show that the judge, who is often the judge that's reviewing the motion, is the person shouldn't have done it as a matter of legal error. So not only do you have to show that the probable cause is somehow lacking, but you have to show that that was essentially apparent on the page so that the judge made a legal error in issuing it. So it's difficult for twofold. And so as a result of that, I don't have high hopes for this motion to dismiss. I don't think it's going to go anywhere. That's my presumption going in, but we'll read it and see if they make better arguments than I'm anticipating. Fun and exciting. Great. Moving on. Let's do that. We are in the state of Minnesota, in the county of Candy, Ohio, in the state of Minnesota versus Nick Rekeita, with defendant's notice of motion and motion to void the warrant, suppress the evidence, and dismiss the charges for lack of probable cause. Cool. Let's see what you got. All right, so we have a hearing we'd like to do. Fine. The search warrant was not supported by probable cause. Sell me. Defendant herewith asked the court, pursuant to the Fourth Amendment to the United States Constitution, Article 1, Section 10 of the Minnesota Constitution, to suppress all evidence resulting from the state's unlawful search and seizure of defendant's home on May the 23rd of 2024. Unreasonable search and seizures are prohibited by the United States and Minnesota Constitutions. The touchstone of the analysis under the Fourth Amendment is always the reasonableness in all circumstances of the particular governmental invasion of the citizen's personal security. When a defendant seeks to invalidate the warrant, the two-pronged Frank's test requires a defendant to show that the appellant deliberately made a statement that was false or reckless disregard of the truth, or the applicant deliberately made, in this case, the police, and the statement was material to the probable cause determination. Okay, yeah, so that is basically what you need to show. All right, so the police, when they're applying for a search warrant, they need to disclose every fact that would go against them that they know about. They don't need to go look for it, but if they happen to come into their possession during their investigation, if they happen to find evidence or information that would suggest against the person, they do have to include that. So they have to exclude anything they know that's exculpatory. And obviously anything they do say has to be true. So they can't lie. They can't lie by just making shit up. And they can't lie by omitting evidence that goes the other way that they actually have knowledge of. Again, they don't have to necessarily go look for it, because that may or may not be apparent in the investigation at that point. But if they do know, they have to include it. So they have to be honest, because it's a statement under oath. It's a sworn statement. So it has to be true. So, no duh, right? So it can't be lies. And also that it's material. So if the cop, lied about something completely inconsequential, I don't know why they're doing this, but, just as a hypothetical, if they're like, oh, the person has blonde hair, but their hair is actually black, but it doesn't matter, and the cop knows that, and for some reason they're making shit up, but it doesn't matter, either here or there. Like, I saw the person walk into the house with the drugs, in a bag, marked drugs, while they said, ha ha ha, look at the drugs in my bag that I have on a videotape. Also, their hair was black, but it's really blonde, and the officer knows that, and for some reason lying. Yeah, it doesn't matter, because it's not material to the thing. So it has to manifest in some way that would go to the weight of the thing, in a way that someone somewhere is going to carry about. Great. So that's what they're talking about. And as Luke notes, Frank's doesn't work. Yeah, I as I said at the start, this is not going to work. But I'm explaining it so that we all understand where we're coming from. Great. A concerned citizen is generally presumed to be reliable, generally speaking. However, that showing can be rebutted. Yes. But of course, that would have to be apparent to the police officer at the time. This would have to be something they, again, have knowledge of. So if it's somehow that the person is just, I don't know, a convicted perjurer, but somehow the police don't know that, which I suppose isn't that unlikely. They might not necessarily be doing a background check on any witness who happens to come in their door. So if the person happens to be a convicted perjurer, and they, the guy comes in the door and in an unrelated case says, oh, this is so-and-so, and the police rely on it, then, okay. So it has to be something that would be apparent to them at the time or known to them at the time. Okay, fine. However, the showing can be rebutted since the defining characteristic of a concerned citizen is their motivation. Well, I don't think that's necessarily true. I don't think that's the defining characteristic. I don't think that's true. Their motivation. I don't think their motivation is either here nor there. Their motivation is not necessarily, well, the motivation might be informative, but it's by no means dispositive. If I just hate your guts for some reason, if I just hate you in particular, but I'm otherwise reliable, and I'm like, yes, I saw the person with the drugs carry the drugs into the house and blah, 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 right? Then it's not dispositive. It might be informative as to my reliability, but not dispositive, so I don't think about that. So I wouldn't say it's defining, but okay. More defining would be their ability to actually observe it. Do they have the capacity to observe it? Were they there? I'm not sure I agree with that, but fine. Some factual background must be provided so the issuing judicial officer make a determination about the citizen's motivation. The collective knowledge doctrine also applies. Yes, that's true. So as long as any of them know it, then all of them know it when it comes to the police. Generally speaking, that's true. Going further, a search warrant is void, and the fruits of the search must be excluded if the application includes intentional or reckless misrepresentation of the facts finding to probable cause. Sure. In McGarth, the officer characterized his informant as a concerned citizen, but was instead a confidential informant. Okay. It appears that the applicant relied not on an informant in the traditional sense, but on the public exhortations of a self-described citizen, namely Aaron Imholt. Okay. All right, fine. All right. Tell me more. In this case, it readily appears the applicant knowingly and willfully misled the court in his application for warrant. In the warrant, the applicant informed the court that he was able to review the video that was taken off defendant's YouTube and Rumble's social media sites. The video is from 5/21/24 and is of Nicholas in his basement studio talking about court appealing ruling he lost. What the applicant failed to disclose to the court is the video he was watching must have been altered from the original. What do you mean? How? Why must it have been altered? You're just gonna say that without telling me why? Why must it have been altered? And even if it was it altered in a way that's material? Okay. What the applicant, given the self-proclaimed extensive amount of experience, the applicant should have stated the video bears the indicia of alteration that are readily apparent to any layperson, even more so to a self-described expert who professed to have watched the defendant's video over an extended period. Oh, okay. Should the court rule in defendant's favor on this issue, defendants request that this expressly be entered against the applicant as an adverse integrity information under Giglio, which basically is a follow-on case to Brady, right? No. It's a follow-on case to... Yeah, it's a follow-on case to Brady, dealing with police knowledge of stuff, and has the direct purpose of implicating the applicant's credibility and adversely impeaching the warrant. I don't have high hopes for this argument, but okay, let's keep going on. Statement of reasons. Applicant offered the initial basis for the issuance of the search warrant. A report received on May the 16th, 2024. Giglio's about impeachment. That's true. Yes. Yeah. Alleging possible child neglect and controlled substances use. Okay. Applicant failed to disclose the judicial officer. Yes, that's right. Yes, you're correct. So Brady by its own terms extends to any information that would tend to indicate that the suspect didn't do it. So any evidence that would mitigate either liability in he didn't do it or mitigate punishment in he shouldn't be that responsible. And Giglio dealt with anything that could be used to impeach a witness, which also inherently would make it less likely. So it's a follow-on case to Brady, but yes, it dealt with material that could be used to impeach, which makes the witness less credible. Yeah, that's right. Good. Yeah, good. Yeah, good stuff. Yeah. The letter was sent to Candy-Ojai County Sheriff's Department from Candy-Ojai County Health and Human Services and was authored by Children's Supervisor Alicia Sweep. Okay. In this letter, Ms. Sweep informed the Sheriff's Department that 2 days prior to applicant's search warrant application, that the report does not fit the definition of child abuse or neglect as defined in relevant law reporting and maltreatment. Applicant's failure to inform the judicial officer of this letter prevented the judicial officer from approaching the warrant based on the report with facts necessary to authorize the intrusion on the home and repose. No. Because the warrant didn't seek to enter to look for evidence relating to maltreatment. So no, it doesn't work that way, right? The warrant is looking for drugs. So that's what the warrant is for. So this other stuff dealing with, okay, there isn't evidence of child abuse under some definition. If they were looking for evidence relating to child abuse, then sure, it should be in the search warrant, but they're not. They're looking for evidence relating to drugs. So why would it be in the search warrant? Because it's not related to the thing they're searching for. Whether or not they're abusive to their children has really not much to do with whether or not there are drugs in the house. So the one doesn't really speak to the other. So no, but okay. Applicant's failure to inform the judicial officer of the prior determination is material, as the initial predicate for seeking the warrant has already been deemed insufficient. But that isn't the initial predicate. And even if it was, it doesn't matter. The police's initial impetus is neither here nor there because investigations mature. They change. The police start looking into one crime and discover another crime. It happens, right? So the police's initial thought is we're going to go investigate this guy for, I don't know, bookkeeping fraud. And he's like, oh, we don't have a lot of good evidence on the bookkeeping fraud, but along the way, we discovered evidence of a murder we're really interested in. So it's like, yeah, and we got a letter from the comptroller who said, after our investigation, we determined that there was no bookkeeping fraud after all. I don't know how much, the police moved on. And I don't know how, that has much to do with anything, to be honest. So I'm not buying that one. Applicant asserted that defendants in Imholte may have recently had a falling out. This is an intentional misrepresentation. Okay. In the 5/22/24 video blog by Imholte, referenced by applicant, Imholte makes clear his relationship had degraded far beyond a falling out. Imholte, stating at 104:32, says, "Peace, brother, is not what Nick told me when I said I wouldn't be hanging out with him anymore. The text I got was something about what a flabby, misshapen, doughy piece of shit I am, and the world would be a better place if I killed myself." Imholte at 106:27 then states he communicated to Nick, "Okay, addict," and then they blocked him from his number. I don't know, that sounds like a falling out to me. Sounds like things are not necessarily going super well in their relationship right now. So I don't think that's an intentional mischaracterization, but okay, fine. Applicant admitted from his affidavit that Imholte had made several threats, ranging from thinly veiled to fully throated against defendant. Imholte stating at 102:44, said, "Nick, sweetie, baby, first of all, get help. Second of all, you better hope, and I said this last night, you better pray to God I don't say what I want. If I say what I want, MFR, that's Mount Vesuvius. Let's make a quick rule for Nicky boy here. You keep my name out of your fucking mouth in ways that I like, and I can promise I'll be as good a boy as I can." Yeah, I don't think that's much in the way of threats, but okay. Imholte then proceeded in 103:31 to compare himself to Lefty Rothenthal, popularly analogized as Eighth Rothenstein from the film Casino, and asked, "You want to keep a guy like that happy, right? Because he could blow your shit up, right?" Yeah. Imholte made this comparison and similar threats at multiple points throughout the video. Applicant misrepresented both the extent of the falling out between Imholte and defendant and Imholte's overt personal animus, bringing his statements well outside those of a concerned citizen. Applicant stated that on 5/22/24, Imholte did a video blog where he talked about Nicholas and insinuated controlled substance use, and also referenced a video blog that Nicholas put online on 5/21/24 that has since been taken off the internet. Aaron Imholte clearly states at 55 minutes and 26 seconds in the video blog, "So this woman who clips a bunch of shit from my show, from Nick's show, DM'd me this. It was Nick telling a disjointed, drunken story on a stream. Here's the clip that got me riled up. The accompanying clip that Imholte plays in the video is 1 minute and 11 seconds long. Applicant states the defendant's video blog is 4 hours and 4 minutes long. Applicant therefore knew the video presented by Imholte in his video blog is an altered rendition of the video that cannot be authenticated." Applicant failed to inform the judicial officer of the unknown provenance and unreliable nature of the clip. Yeah, no, no, I appreciate your enthusiasm and all, but no. The thing speaks for itself a little bit on that one. So, okay, so we included a minute 10 of this video as part of the evidentiary picture, but it is the moment of criticality relating to the thing. So, no, I don't think so. But okay, fine. Applicant misrepresented they've been able to review the video as taken off Nicholas YouTube's and Rumble media sites. Applicants say the video was taken off the social media sites. This was a misrepresentation as they are placed in private status. Wow, talk about trying to slice it really thin. That's good. Oh, it wasn't taken off, Your Honor. It was merely set to private status. Yeah. Okay. A distinction without a difference, my friend. The distinction without a difference. They don't care. If a user attempts to access the video link on each of the social media platforms, they're informed the video is private and the user must have special permission. In order for applicant to have been able to review the original video on YouTube, he would have had to serve a warrant on Alphabet, the parent company of YouTube. This warrant has not been produced in discovery. Well, okay. Unless he got the video from somewhere else. So he's like, oh, it was deleted on YouTube and I got it from somewhere else. If it was uploaded somewhere else, then, you know, cool. You know, it's fine. Maybe there's no warrant because we got it from somewhere else. Most likely, applicant's assertion that he was able to review the video did not necessarily necessitate serving warrant on Alphabet, because applicant reviewed an edited version titled Nick Rekeita's Drunk Stream After Losing His Appeal. In discovery, the state produced a PowerPoint presentation with what purports to be a clip of defendant's May 21st, 2022 live stream video, as well as an image purporting to be a screenshot of the same. Not only is this video titled differently, it came from a different YouTube channel, Backwards Internet, and was uploaded on a different date and time from the original. Yeah, I mean, almost by necessity, it would be in a different date and time because it would have had to be re-uploaded. So yes, it's not the original, it's a copy, but it's fine. It also contains a watermark not present in the video. Oh boy, oh boy. Yeah, that's definitely gonna do it, man. Oh my God. The re-uploaded video has a watermark that isn't in the original. Close the case, boys. Close the case. Everyone's going home. Jesus Christ. The watermark is open and notorious. Ooh, open and notorious. Ooh. Are we trying to seize land in are we trying to seize land in adverse possession? Open and notorious. Ooh. In the lower right-hand corner of the video, it appears to mimic the branding of the video at its host channel. Yeah. Applicant did not review the original video. No one cares. This is a misrepresentation of material fact. It is not material. It is the defendant's video. A watermark has been applied. Ooh. Ooh. For these reasons, pursuant to Frank, the court must find the search warrant devoid of any reliability, lacks necessary cause. Yeah, no. And as I stated before, even if somehow these arguments were correct, which they're not, it still wouldn't matter anyway, because a warrant is, by its nature, built on a probable cause, which is built on the totality of all the evidence combined. It is not common in most applications, although there are of course exceptions, but there's usually not the smoking gun, right? That is not usually a thing. That's usually not a thing even at trial, right? It is not the norm that there is the smoking gun. You know, it's not the norm that there is the thing that proves the case unto itself. That is not the typical experience. More common is we're building a whole bunch of things that together build a picture. Okay? And so in a probable cause, that's the same thing. And we're trying to knock out one of these many pieces from the puzzle. Okay, you can knock out one of the many pieces, but the problem is that in combination, the other pieces still are reliable. And remember, you're only trying to get to like a 1 out of 10 certainty. You're only trying to get to probable cause. You're not trying to get to beyond a reasonable doubt. And even then, knocking out one piece of evidence may not do the trick, because you can disregard pieces of evidence as a juror, but I digress. So the problem is, first of all, no. Second of all, even if yes, you've successfully knocked out one piece maybe of the overall puzzle. You know, so no. And then third of all, even if somehow you did that, you can't show that the judge was unreasonable for either A, relying on it, or B, even if the judge had sniffed it out, that it would be legal error for the judge to issue it anyway. I appreciate your diligence, counselor. You're definitely getting your money's worth out of this one. And I appreciate you trying to find the flaws that you can find, but no. What else you got for me? The firearm seizure was unlawful. Okay. Even if the court finds unsupported and contradictory statements by the applicant, and incidentally, they are supported by other things, but I digress, because they're statements by the applicants, in this case, the police. The applicant is the police officer, the applicant for the search warrant. So they are supported by other things in the search warrant. Okay. Sufficient to form probable cause, the seizure of the alleged firearms was independently unlawful. Okay. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable search and seizure shall not be violated, and no warrants issued but upon probable cause supported by oath and affirmation, and particularly describing the place to be searched and the persons or things to be seized. That sounds a lot like the Fourth Amendment. The Minnesota Constitution contains nearly identical language aimed at fettering intrusions of the government upon the right of the people. Each constitution requires that a search warrant particularly describe the thing to be seized. Yes, it does, but then once you are there and looking for things you find in the places that you are allowed to look, you can also seize to the extent they are indicating of either of contraband or evidence relating to anything. They don't even have to be related to the reason you were there in the first place, right? If the police go in your house and, they're there searching for drugs and they find the dead body on the floor, it's like, whoa, this dead body has nothing to do with the drugs. Can't take that, can't take that. No, that is not how that works, right? As long as they're in the place in the first place lawfully, and they're looking in the places they're allowed to look lawfully, and they happen to discover evidence, even if it's evidence completely unrelated, then, seize that too. That's just bonus. That's just bonus. So they're allowed to look with their eyes and take things they find. And the thing with drugs, of course, is you're allowed to look in any place that drugs might be found, which basically is everywhere. Incidentally, in case you care, as long as we're here to try to learn something of legal value, the places that you're allowed to search are the places in which the thing might be readily found. So, for example, if you were looking for a stolen car, you couldn't go look in, say, a bedroom closet, because not so much. Cars can't fit there. The car is too big. It is too big. The thing is too big for the container. It does not fit there. But, the thing with drugs is you can kind of find them everywhere. So drugs kind of give you an excuse to search everywhere, or a reason to search everywhere maybe. But either way, right? So yes, we can kind of search anywhere where drugs can be found, which is kind of everywhere. So yeah. The requirement for particularity serves to prohibit law enforcement from engaging in a general or exploratory search. By limiting authorization to search for the specific thing and things which there is probable cause to search, the requirement ensures the search will be carefully tailored to its justifications and will not take on the character of a wide-ranging exploratory search that the framers intended to prohibit. Yeah, but drugs though. The particularity requirement, what crime would the guns be evidence of? Well, among other things, a violation of 18 U.S.C. 922 G3, because it would be unlawful possession of a firearm by a person who is an unlawful habitual user of a controlled substance. But I digress. The particularity requirement prevents officers from conducting a general exploratory rummaging of a person's belongings. The requirement is one of practical accuracy rather than hyper-technical one. Practical rather than hyper-technical. Practical, yeah. In assessing whether the warrant is sufficiently particular, we consider the purpose for which the warrant was issued, the nature of the items to which it's directed, and the total circumstances surrounding the case. Even in circumstances, unlike the instance case where the affidavit in support of the search warrant is constitutionally sufficient, which there's no problem with this one, there are occasions in which law enforcement exceeds the scope of the warrant. It is possible, as I described. Are we searching for a stolen car? Did we go look in their toilet? Then yes, the stolen car will not be found in the toilet, I assure you. So yes, it is possible. The Court of Appeals, while overruling the district court, provided an analytical framework. In Sexter, the law enforcement executed a search warrant that authorized the seizure of, among other things, a white dish towel-like cloth used by suspects following a sexual assault, which is believed to be located in the red shed. Law enforcement only seized 4 travel towel-like items, 2 that are entirely white, 1 that's white with floral design, 1 that's light blue, and 1 that's a stripe pattern. Following the contested omnibus hearing of the motion to suppress the seizure of the blue and white striped towel, claiming law enforcement had exceeded the scope of the warrant, the district court reasoned, if the blue and white striped towel were purely or mostly white like other towels, the search warrant would easily cover the blue and white striped towel. If the victim had described the towel as light colored or simply as a towel, the towel would be omitted. It is not, however, plain white as described in the warrant. The district court rejected the state's argument considering plain view. Okay. The state, pursuant to law, sought a interlocutory appeal, which is an appeal while the case is ongoing, which the Court of Appeals granted. The Court of Appeals held that because this involved a determination by the district court that law enforcement exceeded the scope of the warrant, it was not a challenge to the validity of the warrant itself, but to the way it was conducted. Which, fair enough. An argument that seizure exceeds the scope of a warrant is a challenge to the actions of the officer who executed the warrant. The two are somewhat interrelated in the sense that the degree of particularity of the search warrant may make it more or less likely that officers will seize items that are not described or arguably not described in the warrant, and defendant conceivably could make either argument while moving to suppress. Ultimately, the Court of Appeals vacated the order of district court, finding that even if the blue and white striped towel was not described in the warrant, there is at very least a strong relationship between blue and white striped towel and white dish towel that is described. Yeah, that sounds more correct to me, which kind of cuts against the argument that we're apparently trying to use this for. All right, so let me summarize what just said. All right, so the police in that case are looking for a towel they believe was used in a sexual assault. Okay, the victim says it's a plain white towel. Cool. The police, when searching for it, find some towels. Some of them are white. Some of them are white with stripes. Some of them are light blue. They seize them all. The district court said, hey, the victim said plain white. And this one's like white with blue stripes. And the Court of Appeals is like, close enough, right? Close enough. It's practicality, not hyper-technicality. It's a dish towel. It's roughly the same, it's roughly the correct shade. It's not black, it's not, lime green. It's white or white adjacent. Close enough. Yeah, that sounds about right to me. Okay, cool. No such strong relationship exists between the items described. Well, insofar as that's true, that's true. We're looking for drugs. Guns are not like drugs. That's true. I will give them that. With particularity on May 22nd, 2024 warrant and the seizure of the firearms alleged to have been found at defendant's home. The warrant authorized defendant's home to be searched for the following: controlled substances, including methamphetamine, cocaine, or any other controlled substance prohibited by law, and paraphernalia commonly associated with sale or use of controlled substances. Items that would show controlled substance use that would not qualify as a legal drug paraphernalia. So we're looking for drugs, which means we can look everywhere. Pretty much. The May 22nd, 2024 warrant authorized state actors to seize and keep said property and things in custody until dealt with according to law, including authorizations to have the seized property and things analyzed. The controlling law regarding seizure of items not described in a warrant is Mickelson, a 1973 Minnesota case holding in part the following. The rule in Minnesota is that police executing a search warrant may seize items not described in the search warrant, provided there's a strong relationship between the seized and described items. Phrased differently, it is proper if the seized items clearly and definitely relate to behavior which is prompted by the issuance of the search warrant. All right, I agree that that's a basis by which the police could seize a thing, but I have a difficult time believing that is the only basis. So yes, you can seize an item not described if there is a strong relationship between the two things, right? I'm looking for a white towel. This one's white and blue stripes. That's close enough, right? They're both dish towels. They're white and white adjacent. Even the light blue one's is white adjacent. So, close enough. Close enough for government work, okay? So yes, I agree that that is a reason that police can search. What I have a difficult time believing in Minnesota is that is the only reason. That makes no sense. That makes no sense. I have a really hard time believing that if the police are there looking for drugs and they find the dead body, right? And they find a dead body, they can't seize the dead body because it's unrelated to the drugs. That does not sound like the correct statement of the law. So while I am sure that this is correct as far as it goes, I somehow don't believe this is the only example. This is the only thing. That doesn't sound right to my ear. None of the described behavior prompting issuance of the search warrant is in any way related to the possession of firearms. True. The behavior described by persons unknown and a person known to have great animus, perceived and also isn't the pastor known? Because he came in and reported. They mentioned the name. Some of the people are known. We know who they are. What are you talking about? The behavior described by persons unknown and person known to have great animus towards the defendant, perceived nonconformity to the mores of a religious community, and observations of alleged inebriation viewed through the prism of a third party. Yeah, but the third party, yeah, can know what it looks like. And yeah, all of which were attributed to the applicant to the consumption of unlawful narcotics. Yes, that was the conclusion reached by the narcotics officer. He's like, yes, I am trained in this. I observed it. This is what I think is going on. That's kind of what they do. The applicant, despite claiming defendant, is known to applicant and Kendi, Ohio County Sheriff's Office because of swatting calls, failed to inform the judicial officer of the likely presence of firearms. Again, why would they necessarily? Why would it have mattered? Which the state disclosures were revealed to have known to state actors, but why would they tell the judge that? What does it have anything to do with the price of tea in China? What is the only reason to mention firearms in the warrant is because we want to do a no-knock warrant, right? That'd be the only reason to mention it. Like, oh, by the way, they have firearms and we're concerned about getting shot at. So can we have a no-knock warrant and can we go in at the dead of night? Right? Otherwise, like, why are you mentioning it? Because it has nothing to do with drug possession in and of itself. It only has something to do with, can we search, you know, at nighttime? And can we just bust down the door? So what does the possession of guns have anything to do with drug possession inherently? Not much. Now, once you find the guns, now you have evidence of another crime, but, you know, I digress. The omission renders any suggestion of a nexus between the purpose for which the search warrant is issued, the alleged presence, and seizure of firearm devoid of rational basis. Yes, probably that's true if that were the only circumstance in which you could seize a thing, and I have a really hard time believing that is the correct statement of the law. That doesn't sound right. So yes, there's not much of a nexus between the two insofar as it goes. But once you're there, you know, you could seize it because it's evidence of another crime. For example, possession by an unlawful individual under either federal or, I assume, a state law analog that we've been talking about. So yeah. So no. 2 years after Mickelson, the Minnesota Supreme Court lightly tapped the brakes on the rule established therein. Okay. In a case involving the seizure of papers bearing the defendant's name found in a bureau drawer with drugs, which were indicated on the search warrant, the court held a lesser standard apply. Although one might argue there's a strong relationship between the papers and the narcotics, we prefer to rely on the requirement of Warden v. Hayden, U.S. Supreme Court 1967, that there be a nexus, automatically providing in the case of fruits, which is just anything we happen to find along the way, instrumentalities, or contraband, between the item seized and the criminal behavior. Under this test, it's clear the officers had probable cause to believe the papers were seizable because they were immediately facially recognizable as evidence which would connect the defendant to the drugs found in the drawer. Okay. The court reasoned that since the papers came into plain view of the officers when they acted within the scope of the warrant, and because they had probable cause to believe the papers were seizable, the search was proper. Even if the court determines that the May 22nd, 2024 warrant is lawful, the seizure of firearms alleged to have been found at the home was unlawful, and any evidence thereof must be stricken. I have a very difficult time believing that is the correct statement of law. I think counsel over here might not necessarily be telling me the full law on such issues. I have a sneaking suspicion this is not correct. It doesn't sound correct. It's correct as far as it goes, but I think maybe there's some more things they're not telling me. Here, the officers had no need to seize the alleged firearms to prove their alleged possession of narcotics. The circumstances of the instant case lacked even the lesser standard of a nexus, as articulated in Stevenson. The plain view doctrine cannot rescue states actors from their negligence. The Supreme Court described this doctrine, its benefits and dangers and pitfalls in a seminal 1971 decision. It is well established. Under certain circumstances, the police may seize evidence in plain view without a warrant. But it's important to keep in mind that in the vast majority of cases, any evidence seized by the police will be in plain view, at least at the moment of seizure. The problem with plain view doctrine has been to identify the circumstances in which plain view has legal significance rather than simply being nominal concatenants of any search, legal or illegal. Okay. As an example of the applicability of plain view doctrine is a situation in which the police have a warrant to search a given area for a specified object, and in the course of the search come across some other article of incriminating character. When the initial intrusion that brings the police within plain view of such articles supported not by warrant, but one by recognized exception to the warrant requirement, the seizure is also legitimate. In other words, we're there and we have eyes and we can see. We're already in the place. We got the warrant to get into the place. We're already there. We can see with our eyes. That would be the exception that they're referring to. The police may inadvertently come across evidence while in hot pursuit of a fleeing suspect, which would be a different exception to the Fourth Amendment, also an exception to a warrant, as long as we want to learn something of value. So in addition to a warrant, why else might we get into a house? Well, consent will do it. And what else other than warrant and consent? Well, a exigent circumstance, like, a shooting is happening and we hear the gunshots happening inside the house. That'd be an exigency, right? We don't have warrant. We don't have probable cause, or apologize. We don't have a warrant. We don't have consent, but we hear gunshots going off inside the house. Don't exactly have time to go get that warrant. Exigency. All right, what's another reason? What is another reason we can go into a house, or any place, incidentally? What's another reason we can go in a house? Well, in addition to a warrant, in addition to consent, in addition to exigency, hot pursuit of a fleeing felon. The police are conducting a chase of a guy, and the guy runs through your house. And while the guy's running through the house, the police run through your house, and they see you with the drugs. Incidentally, that was actually a case that actually happened. And I think it might have gone to the U.S. Supreme Court, because I remember reading it in law school. But yes, that actually happened. The police were chasing a felon. The felon broke into a guy's house to escape from the cops, ran through his living room, and ran out the back door. The cops, chasing the felon, ran into the house, while the guy who owned the house is basically like having a drug party, except in tea style. Like, he's having tea with his daughter, except tea is drugs with his drug friends. Instead of high tea, it's high drugs, okay, in his living room. And the police see the high drugs, and they arrest everyone in sight for the drugs. And I'm like, that's not fair. You didn't have a warrant. The Supreme Court's like, we laugh in your general direction. So, yeah, that actually happened. Good times. Any object that comes into view during the search incident to the arrest is appropriately limited in scope under existing law, may be seized without a warrant, as long as we're there and looking, ... Finally, the plain view has been applied where the police officer is not searching for evidence against the accused, but nonetheless comes against an incriminating object. So if we're searching for some other reason, unrelated to you, but we're there anyway, then, cool. So we were there searching for the drugs relating to Billy. But while we were there searching for the drugs relating to Billy, we found the murder plot from Jones, who left it on the table. I'm planning on conducting a murder. Would you like to join me? Says Jones in his papers. Oh, this is really interesting. We were looking for evidence against Billy, but we found the evidence against Jones. Maybe we should go follow up against that in some way. Yeah, just again, bonus time. What plain view cases have in common is the police officer in each of them has a prior justification for the intrusion. In the case in which he came across the inadvertently of the piece of evidence, the doctrine serves to supplement the prior justification, whether it be warrant for an object, hot pursuit, search incident to lawful arrest. That too, incidentally, I suppose, yes. But that is interesting when it comes to the home, incidentally. So an arrest warrant doesn't get you in the home unless you know the person's in the home. So you have to know they're there. But if you do know they're there, you can go into the home with the arrest warrant. And then once you're there, you can do a search incident to the arrest. So in case you care, I'm just here to help. Or if you were doing a search incident to any arrest, right? We're doing any arrest and, oh my God, these are drugs on you. We were arresting you for, I don't know, littering. And in your pockets, we found the cocaine. Well, that's really interesting. Also, we found the note from Billy. We found the note from Billy that you thoughtfully got notarized for some reason. You're like, yes, I would like to enter the murder plot. I hereby sign to it, as a fiance, agreeing to the murder plot that I have thoughtfully got it notarized and sitting in my back pocket. Well, geez, that's really convenient. I think we're going to go investigate that one too. So all those things would be fine. Yeah, good times. All right. Lord. Of course, the extension of the original justification is legitimate only where it's immediately apparent to the police they have evidence before them. The plain view doctrine may not be used to extend general explicatory search from one object to another unless something incriminating until something emerges. The rationale for the plain view exception is evident if we keep in mind two distinct constitutional protections served by the requirement. First, the magistrate or judge's scrutiny is intended to eliminate altogether searches not based on probable cause. The premise here is that any intrusion by way of search and seizure is an evil. So no intrusion at all is justified without careful prior determination. Yes, we would really like not to search and seize people. That is preferable. So we need a good reason to do it. The second distinct objective is that those searches deemed necessary should be as limited as possible. We don't do general search warrants. You can't just go into the house searching for things and stuff. You have to say what we're looking for with some particularity. Here, the specific evil of the general warrant abhorred by the colonists, and the problem is not the intrusion per se, but the general exploratory rummaging in the private belongings. The warrant accompanying the second objective by requiring particular description of the thing to be seized. The plain view doctrine is not in conflict with the first objective because plain view does not occur until the search is in progress. In each case, the initial justification is justified by a warrant or exception such as hot pursuit or search instant to lawful arrest, or by extraneous valid reason by the officer's presence. Yes, if we happen to be in a place lawfully for some other reason, and, magic evidence just happens to appear before our eyes, that would also be fine. The police officer just happens to be at the end of a shift, going through the supermarket, when the note from Billy falls out of your pocket, ... Oh, man. And given the initial intrusion, the seizure of the object in plain view is consistent with the second objective, since it does not convert the search into a general or exploratory one. As against the minor peril to the Fourth Amendment protection, there's a major gain in effective law enforcement. Where once an otherwise lawful search is in progress, the police inadvertently come upon evidence, it would often be of needless inconvenience and sometimes dangerous to the evidence or the police themselves to require them to ignore it until they obtain a warrant particularly describing it. The limits on the doctrine are implicit in the statement of its rationale. The first of these is that plain view is never enough to justify the warrantless seizure of evidence. That is simply a corollary of the familiar principle described above, that no amount of probable cause can justify a warrantless search or seizure absent exigent circumstances. No. Exigency is a reason, not the only reason, counselor. Incontrovertible testimony of the senses that an incriminating object is on the premise belonging to criminal suspect may establish the fullest possible measure of probable cause. But even where the object is contraband, the court has repeatedly stated that enforce the basic rule that police may not enter and make the warrantless seizure. Yes, that's true. They can't enter just because there's contraband in the house, because how do they know it's there? Right? The fact they find contraband isn't going to do the trick. How are we getting into the house in the first place? So yes, we need a reason to get there in the first place. That is true. And once we're there, the rule in Coolidge, as modified by Horton, as applied in the circumstance in the instant case, demonstrates that even if law enforcement intentionally or inadvertently discovered the alleged firearms, the seizure was unlawful. No. Given the rapidity, and also inevitability will also come into the back end on this, by the way, it would be inevitability. It's okay, so if we would have discovered it inevitably, they're not going to suppress it either. So that, yeah. So, yeah. Given the rapidity with which the applicant was able to secure the initial warrant, 4 minutes from a signature to approval, and the arrest of both adult occupants of the home, as well as their adult visitor, and removal of defendants minor and child by law enforcement, securing a warrant for the firearms would have neither been inconvenient nor dangerous. Yeah, but if they could have, then it's inevitable. And it comes in anyway. So you're like, oh, they shouldn't have gone a warrant first. They could have? Okay, then no one cares. Yeah. Because the entire premise here, by the way, is that they had a reason to apply for it, right? It's like, oh, we have a warrant now. Why did we get the warrant? Because we have probable cause. What's our probable cause? Well, we found guns were in the home of a drug user. Well, why is that a problem? It's a violation of law. So we'd like to seize the guns. Oh, okay. So we have a basis for the warrant because we see it with our eyes. Well, it's like, well, if we could have gotten the warrant, because then like, yeah, it's fine. The seizure of the alleged firearms was therefore warrantless, I guess technically, without any exigency. I will tend to agree with you. There's no exigency. That's true, technically. That must accompany such a seizure. No. A warrantless seizure is per se unreasonable. Yeah, okay. A search conducted without a warrant is unreasonable unless satisfies one of the well-delineated exceptions to the warrant requirement. Since none apply here, I can think of some that might apply. And as such, the fruit of the poisonous tree doctrine requires the underlying firearms charge be dismissed. April and Holtay statements are inadmissible as to the defendant. Why? Is this going to be the counsel thing? Or is that where this is going? Because that's the only thing I can think of. Or is that what we're doing now? Are we going to say the statements are inadmissible because she was denied her right to counsel by Nick? Is that where this is about to go? How much lol fuel is there going to be in this complaint? Or this answer? How much lol fuel is there about to be in this thing? Okay. The statements are inadmissible. Why would they be inadmissible, counselor? This should be good. April M. Holtay's statements to Deputy Pomplin are inadmissible as their testimonial. But they're not being used against her, so what does it matter? And were made after Miss M. Holtay was given Miranda and invoked her right to remain silent and her right to have a lawyer questioning. But they're not using the statements against her. So it doesn't matter. So, yes, if we were prosecuting her, that might be a very valid line of argument, right? We're trying to prosecute April. Oh, you can't use the statements of April against April. Why can't I? Well, I obtained them in violation of Miranda. Oh, okay. But you see, the thing is, the Miranda right is your Miranda right. It protects you. It protects you. You can't invoke the Miranda rights of a third party. That doesn't make any sense. What? You can't do that. Statements are non-testimonial when made in the course of a police interrogation under circumstances objectively indicating the primary purpose of the interrogation is to enable police assistance to meet an ongoing emergency. Okay, so now you're going to describe what is and is not testimonial. For the purpose of this discussion, I will concede they're testimonial because I don't care. I just don't care. There are testimonial when in circumstances objectively indicating there's no ongoing emergency and the primary purpose of the interrogation to establish or prove past events potentially relevant to later criminal prosecution. Okay, so in case you care about this distinction, and I'm not sure why you would, there is a distinction in the Fourth Amendment where if the police are trying to solve an ongoing emergency, then the evidence is not considered testimonial. The ultimate example of which would be you're a bomb maker, right? You're a bomb maker and the police have arrested you and they're like, what's the code? What's the code? You know, to disarm the bomb. What's the code? You know, and he's like, I want a lawyer. Screw that. Screw that. I want the code. I want to remain silent. Damn you and your lawyer. Damn you. Give me the code. Oh, the code is 12345. Well, what a weird coincidence. That's also the code of my luggage. And they enter it and it disarms the bomb. And you're later like, oh, I invoked my right to remain silent. I invoked my right to a lawyer. And then once again, the courts are going to laugh in your face. They're going to laugh in your face because it's like, yeah, no. I understand this incriminates you, but no. They were trying to solve the emergency. It was necessary for the emergency. You don't get the protection of the Fourth Amendment, you dirty, dirty bomb maker. Please enjoy jail as these statements are used against you. So that's kind of what they're talking about. Not really applicable here, but yeah, anyways. Statements to police made in response to the questioning by the purpose of establishing or proving past events for later criminal prosecutions and not to enable police assistance to meet the ongoing emergency are testimonial. I can see that these statements are testimonial because I don't care. I don't care that they're testimonial. I'd care a lot if it was an emotion to suppress with respect to April. I'd care a shit ton if it was an emotion with respect to April, but I don't care because Nick can't invoke the rights of a third party. Jesus Lord. On May 23rd, 2024, exterior to defendant's home, April M. Holty was Mirandized by the deputy. When asked if she'd like to say anything, April told the deputy, "I'd like to remain silent until my lawyer's present." Deputy ceased any attempt to question further. Approximately 4 minutes later, deputy headed towards the house to retrieve a pair of shoes for April. Deputy took control of April. Deputy headed towards the home. When he about-faced and told deputy, "I did Miranda and asked for a lawyer." Okay. Despite the affirmative notice that they asked for a lawyer, deputy conducted a custodial interrogation of her to elicit incriminating statements by telling her side of the story. I don't care. Defendant has no standing to ask. Ding, 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 ding. Defendant has no standing to ask the statements be deemed admissible in her pending case. Or his own. Rather, defendant asked the court to declare that the statements made were being admissible in defendant's case. Get fucked. Get fucked. You don't have standing for that either. Holy shit. You were closer on the other argument. Holy shit. You were closer on the gun thing. God damn. You were closer on the gun thing than this. Holy shit. You don't have standing you don't have standing for this bullshit. You can't use a motion to suppress the statements of a third party obtained in violation of Miranda. What the fuck do you think you're doing? Holy shit. David says there's a confrontation issue. There may or may not be a confrontation issue, David, but that's not in this motion. So for the moment, I don't care. And also, there's not a confrontation issue. I don't care. So yeah, maybe there is a confrontation issue, maybe there's not. But since it's not in this motion to dismiss, what the fuck are we talking about? What the fuck? Is there a confrontation? It wasn't brought up. So what the fuck are we talking about, David? That's all I have to say to you. What are we doing here? What are we doing here? This includes any video recording as well as notes made. Yeah, get fucked. Get fucked. You were closer on the gun thing. Admitting the statements as evidence at trial will violate the defendant's right to confrontation. How? See State v. Souter? Oh, I might have to look up this bullshit. We might have to look up this bullshit and see why this will violate the right to confrontation. This is going to be some good shit. All right, we'll look up this one because this sounds fun. We're at the conclusion anyway, so we're about to wrap this thing up, and then we'll look up this bullshit citation. The applicant misled the court in seeking the warrant. Had applicant been truthful and relayed the scene, the warrant would not have been issued. Fuck no. You're full of shit. For the reasons above, they should suppress and collect all delivered material, hold the warrant was not supported, and blah, 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 signed lawyer. Yeah, okay, I do appreciate your zealous advocacy for your client. I appreciate you really reaching for the stars on this one. I appreciate you really reaching for the stars and all, but no. But let's look up this State v. Souter bullshit on this right to confrontation because there's no fucking way. So let's look up how this is being massively misquoted because that sounds like fun. Let's do that. Give me 1 second to pull it up, please. Oh, man. 595 Northwest 2nd, 760. State v. Souter. There it is. Great. Minnesota Supreme Court. Also fantastic. Okay. You said 760, 768. Okay, let's go look at 768. Let's go look at page 768 in all of its glory. and low. Because Burke's statements to police remain in response to questioning for the purpose of establishing or proving past events for a later criminal prosecution or not to enable police assistance to meet ongoing immersion, they were testimonial. Therefore, we conclude the district court violates suitor's right to confrontation when admitted the statements into evidence. Am I about to be shown up? Hold on. Why is this okay? What is going on in this case? Am I about to be shown up by some Minnesota state law? Am I going to have to apologize to Nick's lawyer? Hold on. Is there some sort of Minnesota state law bullshit here? What's going on? A testimonial statement made before a defendant's trial by a co-conspirator who does not testify is subject to confrontation. Yes, that's true. If they don't testify at trial, that's true. But that's only true in a limited circumstance. That's true. Okay. Testimonial statement of a non-testifying co-conspirator is subject to confrontation clause analysis. Yes. Okay. So that's true. All right. So that is true. So, and the Supreme Court of the United States has said the same thing. But that's a limited circumstance, and April's not being charged right now as a co-conspirator, so it doesn't matter. So unless April's charged as a co-conspirator, it doesn't matter. So, yeah. But she's not being charged as a co-conspirator. She's not even being charged with, no one's being charged with conspiracy at the moment. No one has been charged with conspiracy. So at the moment, it doesn't matter. But yes, it's true. If she's a non-testifying co-conspirator, then yes, that's true. Because it would violate the confrontation clause. Because you're using the statements of the co-conspirator to implicate the other conspirator. And you have a right to confront. And that person isn't on the stand. So it violates the confrontation clause. So that's true. But that only is true if April doesn't take the stand and is charged as a conspiracy. So I'm back to get fucked. And also, that is even if that were to happen, this isn't the right time for it. That would be in a motion before the trial court. That wouldn't be in a preliminary. Because even if like April had indicated that she's not going to testify or whatever, you'd be like, okay, yeah, there's no reason to suppress at this time. You would say, okay, wait until it actually happens at trial. And then, we can suppress it then. You wouldn't suppress it now. So I'm back to get fucked. So I didn't get showed up. But yes, that's true. If you have statements from a co-conspirator who's not testifying that implicates you, it's a statement that implicates you. Okay, it's a statement that's implicating you. You have a right to confront the statement. Duh, right? It's a confrontation clause. You have a right to confront the statement. You have the right to hear it from the person on the stand and the right to cross-examine. Duh. Okay? Now, if it's a co-conspirator, then they're obviously a defendant in the same case. So you have a right to confront and they have a right not to take the stand. Right? So you both have a right to confront and they have a right to take the stand, not take the stand. So you can't use the statements obtained in violation of Miranda because you're basically using their testimony now without them taking the stand, which obviously you can't do, just generally speaking. You can't, you have a right to confront, but this only comes up if April doesn't take the stand. And since she's not being charged with anything at the moment, or no, that's not true. She was charged. She was charged with a lesser violation. She was recharged, wasn't she? But she's still not being charged as a co-conspirator. And so unless she refuses to take the stand at some later time, this is premature. This is premature. So yeah, because wasn't April like charged at a later time? She was charged with like some 4th degree shit, or am I like having a brain stroke? So yeah. So yeah, well, I was real confident. Well, yeah, and then it's like, oh, I read the thing. I'm like, wait a second, what are they talking about? So yes, okay. So I have to modify, but I'm still basically mocking him. I'm going back to mocking him so I can feel superior. You can't stop me. You can't stop me. Oh, Lord. Let's see. Oh, thank you for the 1,200 of you or so who are watching, by the way. I'm just going to read some super chats, and then I'll take questions or comments for a while, and we can have a discussion. Oh, I should actually just, post a thing that you can ask questions in, and that will make my life easier. Let me do that. I can do that. Ooh, I know how to do this. Okay, so I'm going to engage with my audience by starting a Q&A. Okay, start a Q&A. Okay, ask me questions. Smiley face. Okay, great. I've now started a Q&A. Fantastic. All right, now let me go back to the super chats and read those. Jesse Davin became an uncivilian. Thank you very, very much for hitting that beautiful, beautiful join button. As always, it's appreciated. Brian Ogden gave $2 to say, good day. I'm glad you're actually covering this. I'm glad too. Barbara Thomas gifted 10 gift memberships, which is always appreciated. We love those gift memberships. Thank you very, very much to everyone who supports the Uncivil Law family. Nicola Maxwell has been a member for 8 months. 655 says, thanks, Uncivil. All the other coverage of this is a clown show. Alan Parker, longtime contributor to the channel, has gifted 20 memberships. Brian Gibson has been a member for 21 months, potentially criminal, for $5, says, I just got here. What's your thought on Nick admitting he had hit the best evidence of his stream as a gotcha? What the fuck? That's basically my response. What the fuck? Oh, it wasn't deleted, Your Honor. It was only made private. Yeah, no one cares. I can't remember. I'm not even sure they'd care if you said it on the stand. I'm not sure if you said it on the stand. The message was deleted. Isn't it true that it was merely rendered private? I guess technically. Doesn't that make you a liar? What the fuck, right? I mean, no one cares. Kim Farnham became an uncivilian. I can't remember. Gifted 10 gift memberships. Thank you. And Brian Gibson gifted 20 gift memberships. Thank you, by the way. And also, as I have put on screen, by the way, I have opened an account on Ko-fi.com/uncivillaw, which also allows you to make memberships if you are so inclined. The nice thing about Ko-fi.com is if you donate through there, I only get charged about 3%, as opposed to if you donate on YouTube, where I get charged about 30%. So it doesn't cost you any more money. $5 is still $5. It's just that, or $100 is still $100. It's just that instead of me getting $70, I get $97. So that's a much better deal for me. So, you can donate through there and become a member there. It takes PayPal, credit cards, Apple Pay, and I think like most other forms of payment, if you would like to support the channel on a more ongoing basis and help me, bypass some of YouTube's stuff. Coffee? Yes, it's in the link on the screen. It's literally on the screen. It's right there in the corner. Or maybe you can't see it because it's being blocked by my logo. I don't know. Is my logo blocking it? Do I need to move it to the other corner? I could move it to the other corner. Hold on. Let me just move it to the other corner. There you go. Now it's in the bottom left corner, and it will please you in the bottom left corner. There you go. Great. All right. Let's see if you had any questions that you've put in the Q&A. Kestrel says, how am I doing this morning? So far, so good. I'm glad you asked. I have written a script relating to Harvard as they are being sued by students for their anti-Semitic pervasions. There have been some students at Harvard, Jewish students namely, who feel like Harvard maybe didn't necessarily do all they could to protect them during some of the protests that were happening relative to the Israel-Gaza dispute, and have sued. And the judge, I don't think, it was like last week or something. But anyways, last week or something, the judge said this lawsuit can go forward. It seems like Harvard has been hostile to the Jews, which has never been a problem at Harvard ever before. Harvard has never in its history had any problems with anti-Semitism. This is the first time. What a strange thing to happen at Harvard. So I'm looking forward to recording that story and posting it in the future. Plus, as you guys may have noticed, I have a video editor now. And the video editor has been doing a reasonably good job. So I'm very pleased about that. So that's nice. Do I like your hat, Equestrian? I do. because it's my hat. It's great. So how long till the judge just denies? Very soon. Was there anything that should have been in this motion or just necessary base covering? It's necessary base covering. It's all bullshit. It's creative bullshit, but no. If you're the prosecutor, would you request Nick's phone and YouTube creator content? I'd certainly get the original content, sure. To perfect any issue, sure. Assuming a subpoena hasn't been issued to YouTube already, I'd get a subpoena for it, sure. And any other like videos that I want to use, sure. I'd always want to have the originals if I can. Best evidence rule for if no other reason, right? So you always want to have the original or as close to it as you can get. It's the best evidence rule. So ideally, you don't want to have a copy. You want to have the original. If all you have is a copy, then it's still the best evidence by definition because all you have is a copy. But ideally, you want to get the original. So yeah, of course I'd issue the subpoena, but I wouldn't do it for the purpose of the search warrant. Because once again, like if you're thinking about something like the best evidence rule, or you're thinking about something like hearsay, or you're thinking basically about like any rule that is at trial, just remember those are rules at trial. And the reason the rules are that way at trial is because we're trying to reach a particular confidence level and we need evidence that matches that confidence level. So we don't let garbage in because garbage in, garbage out, right? So if we're trying to reach beyond a reasonable doubt, which on a scale of 1 to 10 is like 9.5 or 9.9, right? So if we're trying to reach, let's say 9.5 on a scale of 1 to 10, we want evidence that is also at a 9.5 level or better, right? So these things are in parity, right? So if we're trying to convict you at trial, then we want the best evidence because this is the best available evidence. We want the best quality, the best, we want the eyewitness. We don't want to hear about it from some other guy. We want to hear about it from you, right? We don't want to see a copy of the tape. We want to see the original and so forth and so on, right? So these things are in parity. They're in lockstep. Okay. But that's only because we're trying to reach that threshold. If we're at probable cause, which is 1 out of 10, then 1 out of 10 evidence will be okay, which, copies and hearsay and all the rest of it's, basically fine. Also pleasing me recently is I just got this thing on my microphone. I got this wonderful little mic plate. See, it's my logo. It's nice. And so now I have the logo that travels with me no matter where I put my microphone, and it pleases me. $25. Maybe a little expensive, but it makes me happy. And hey, what more do you want from $25 in your life, right? The $25 has made me happier. So, hey, that's a plus. So it pleases me. And now it can sit in the corner and look all snazzy. I'm very pleased. Although I'm missing one of the screws and I don't know where to get a replacement. I looked online to see if I can find out like exactly what screw it is. And there's like not very much information about trying to find exactly what screw it is. So I was like, I don't know how to find a screw that's exactly that size. I don't even know where I'd go to find one. Does anyone know where I could go to find a screw that's small? Where can I find like small electronic screws? I'm assuming this is not a thing at Home Depot. Where do I go to buy like a small electronic screw? Radio Shack isn't a thing anymore. Where do I go? Does anyone have any ideas? Help. Amazon's not the worst idea. The only problem there is I don't know exactly what size screw I need. I guess I could just get a variety kit, but that seems wasteful. I know it's silly, but I'd rather spend $5 at a real store just to get one screw than $5 to get 1,000 screws. Because what am I going to do with all the other screws, man? So I just want to go buy the one screw. I'd rather pay $7 for the one screw than pay $5 on Amazon just to get a bunch of screws. Just give me the damn screw, man. I just want the screw. I just want the one thing. Hobby shop? A hobby shop? That's a good idea. Thank you. All right. Anyways, was the motion's argument if the police are searching for the bloody knife, but they find a bloody axe? They can't search a little bit. What did you do this morning? You're in a great mood? Nothing in particular. I'm just in a reasonably positive mood today. This is my experience with depression. Some days you just wind up and you're in a good mood that day. It's just the thing. It's just the thing. I said before and I'll say again that my experience of depression is like on a bell curve. Some days you're on the right side of the bell curve and some days you're on the left side of the bell curve. And today I'm on the right side of the bell curve. I'm feeling relatively positive for the moment. So we take these wins where we can get them. The sun is shining. I've got 1,200 of you here. I've got a cool mic plate. I have an editor. Things are going okay. Yeah. Can the state or judge compel Nick to provide the original stream? Well, they'll get it directly from YouTube, so yes, effectively. Do you only consider a convicted felon someone a convicted felon after sentencing? Yes. Yes, technically. Yes, yes, technically someone's only a convicted sentence after technically someone is only a convicted felon after their sentencing. After sentencing. That is true. So technically, Trump is not a convicted felon. I assume that's the basis of your question. Yes, technically, you're not a convicted felon until you're sentenced. This is true. Farnell and Micro Center. Farnell. I've never heard of Farnell, but I've definitely heard of Micro Center. I'll look into it. And Gnarly Bonesville said, I've watched a lot of interrogation videos on YouTube, and the only thing I've wondered is what's the evidentiary video of these before they're Mirandized? Before they've been Mirandized. Well, there's a couple things. First of all, they might have been Mirandized some other time. So they might have been Mirandized prior to the video starting. So there's that possibility. Second of all, Miranda might not necessarily be required because it's not considered custodial, which is also common. The police invite you to come down to the station and talk to them, and you do. And you're in the room with a detective, but you're free to leave. You're not under arrest, you're free to leave. So it's not custodial, so they don't have to give you Miranda. Miranda only applies if two things are true. Miranda only applies if two things are true. You're in custody and they're asking you questions. Custodial, interrogation. You're in custody, they're asking you questions. If neither of those things are true, Miranda doesn't apply. So if you're not in custody because you're voluntarily talking to police because you came down to the station because they just have a couple clarifying questions for you, don't you know, then no Miranda because you're free to leave. You didn't have to show up and you can leave at any time. And if they're not asking you questions, they don't have to give you Miranda either. You know, so yeah, there you go. You're free to leave, but the officers are sitting in front of you with the door behind them. Yes, they are. They definitely don't want you to leave. They are definitely going to try to exert psychological manifestations to remove your desire to leave. So yes, they are absolutely going to put you on the other side of the table towards the back of the room. The table is going to be between you and the door. The officers are going to be between you and the door, but you're free to leave at any time. All you have to do is get up and walk out the door. But you know, you have to have the balls to do it. I mean, that's just, yeah. So if you don't get Mirandized, you're free to leave? Well, no, not necessarily, because they could, again, be holding you in custody, but not asking you questions, which is also possible. Like, they're like, you're not free to leave. So you're in custody, but they're not asking you questions, right? That happens sometimes. That happens more like at the scene of an event than in a police station, but that would be like a thing. It's like, oh, you're not free to leave right now. You're being detained. So, but they're not asking you questions, so Miranda doesn't apply. So one of those things, yeah, they have to tell you you're in custody some way. So it's like they tell you that you're not free to leave. They place you under arrest. You know, they drag you down to the station. You have to be in custody. If you're in custody, you're in custody, but if they're not asking you questions, Miranda doesn't apply. And we see a lot of those kinds of things too. That happens. And then people talk anyway, because people can't suffer silence and, you know, whatever. Yeah. So that's all the questions. So does an order stand if you refuse? I don't understand the question. The validity of the order is not based on whether you refuse it or not. So the you know, if the order is valid, the order is valid. You can't refuse a lawful order. So I'm not sure what your question is. You can refuse an unlawful order, but of course then you have to know the difference. And you know, good luck. But yeah, I don't understand your question. So yes, the order, if the order is valid, the order stands, regardless of whether you can't refuse. By definition, you can't refuse the lawful order. So I don't understand. Happens with DUIs? Yeah. Yeah. Exactly. They're going to detain you. They're going to arrest you. They may or may not ask you any questions, because the evidence of you being drunk is going to be apparent because, you know, of other factors. So, yeah, I mean, yeah, they may or may not ask you any questions as part of your DUI. And and breathing into a tube is not considered testimony because it's not contents of the mind. So Miranda also doesn't apply there. Miranda only applies to testimony. Miranda only applies to testimony. Testimony is contents of the mind. So if it's not contents of the mind, Miranda also does not apply. Now, something else would apply potentially, like the Fourth Amendment, right? Search and seizure would apply. So like they want to get your blood out of your body. Okay. So that's not a Fifth Amendment issue. That's a Fourth Amendment issue, right? If they want to get the password out of your brain, that's a Fifth Amendment issue. If they want to get the blood out of your body, that's a Fourth Amendment issue. So Miranda only applies to contents of the mind. If they're making you breathe into a tube, if they're making you do, roadside sobriety tests, if they're making you give fingerprints, if they're making you put your finger on a phone to unlock it, then Miranda does not apply because it's not testimony. It's not contents of the mind. How's Houston treating me? Relatively well. Thank you for asking. Biggest pro is that my friends are here. That is by far and away my biggest pro, is that I have friends here. Nate the lawyer is here and Attorney Tom is here. And I see and talk to these people quite frequently. I talk to Nate like 3 or 4 times a week. And we have breakfast together quite frequently. And we used to go to the gym together, but his gym is a little far away from me. So it's a little annoying, but yeah. Yeah, Miranda passed away in 1974 by blade. Yes, he did. Yeah. Yeah, he got stabbed. And one of my personal favorite details, of course, one of my personal favorite details of Miranda being stabbed is they had trouble prosecuting the person who stabbed him. And you know why they had trouble prosecuting the person who stabbed him? Because they had to give him his Miranda rights. Yeah. Yeah. Anyways, yeah, Houston, the biggest advantage is that my friends are here. Other than that, I don't think it necessarily has any particular advantages nor disadvantages compared to any other large city. Although Houston is huge. So there is that. It takes forever. It's like the size of Connecticut. It's a huge fucking city. So it's got like 3 airports, man. It's huge. So getting from one place to another in Houston is really problematic because it's just so big. But other than that, it's, like any other major city. And it's got, pretty much, it's like any other city. Also, it's very humid. That's very true. Yeah. And, I do have a nice little apartment here. I'm looking out of my apartment. It's a nice sunny day. I'm looking at my balcony. It's a nice sunny day. Makes me feel good inside. I do have a P.O. box, that's true. Am I licensed in New York? No, I'm not licensed in New York. I'm only licensed in Texas and Virginia. And the primary, and I would get licensed in more states, and I could get licensed in more states. I'm still eligible to be licensed basically immediately in something like 40 states because of my Texas bar results. I can still use those in I think everywhere that's a UBE state, which is something like 40 states. So I can be licensed basically effectively immediately in any state, basically. The reason not to is twofold. One is the money, because they're all going to want like $2,000 to apply, which is annoying. And also, 2, is the continuing legal education requirements, because every state, except for a few, wants you to do continuing education. And the problem is that no one course applies in more than say a half dozen states, or even a dozen states. But the problem is, as you add more and more states, the ability to find overlap becomes harder and harder. And so just the compliance is such a pain in the ass. So I don't think I'm going to be doing Pokemon catch 'em all style. Unless, this YouTube thing really hits off someday. Unless I start making, really, really big coin, and then maybe I'll apply in every single state and I'll just go inactive just to be able to say like I'm licensed in every state, because that would be kind of cool. So maybe if I get really like, I still have to apply for every state, so I still have to pay like all the licensing fees, but that'd be like, $100,000 give or take. But if I go inactive everywhere, and then of course I'd still have to pay like inactive fees probably in most states, which is usually like half, but that's usually about like, say $100 a year. So it would cost me like $100,000 up front and like $5,000 or $6,000 a year, even in inactive status. But if I ever really like get millions of dollars, maybe I'll do it just to be able to like, yes, I'm licensed in every single state, come after me. And then I could go for the territories. And then we could go for the US, and then we could go for the federal courts. I think there's something like 250 jurisdictions combined. So catching them all could take a while, but it could be fun. It could be fun. I got them all. Be licensed. I'll be licensed everywhere. I'm not sure if anyone's ever done it. You think there's got to be someone who's done it sometime, right? I'm not sure if anyone's ever done it. But yeah, it's like I could be licensed literally in every jurisdiction. It'd probably take a couple of years. But I could technically do it. And the other thing that would make it complicated, of course, is although I can apply in the UBE states, as I mentioned, which is like 40 states, a couple states don't take your scores. Like Florida's one. I think Georgia doesn't take it. South Dakota, I think for some reason doesn't take it. California, I don't think takes it. So I could get like 40 states basically immediately. And then for the remaining 10 states, I'd have to like basically take the bar exam in each of them. And they only offer the bar exam twice a year. So I'd have to like fly, from jurisdiction to jurisdiction. So it might take a couple of years, but hypothetically I could catch them all. I'm licensed everywhere. $49 inactive fee in your state? Hey, there you go. Not so bad. So if for the million subscriber special, there you go. There you go. For the million subscriber special, I will catch them all. So we can go work towards that goal. That'd be good. And then I'll just have to deal with all the paperwork from all the states. Oh, Lord. Do I want to take the California bar? Sure, why not? Yeah, why not? Do I want to take the California bar for you? That would pose an ethical problem for both me and you. I don't think that's a good idea. Also, that doesn't really get me towards my goal. If I take it for you, I'm not taking it for me, and that doesn't really help me towards my goal. And I think if I show up more than once, they might get suspicious. If you don't answer, they'll arrest you. They may or may not arrest you. That's true. They may or may not arrest you, but at least then you have Miranda to protect you. So yes, it's true. If you don't answer the police officer's question, they may arrest you. That's possible. But you're still protected by law. So if the officer arrests you falsely, then then you're protected by Miranda, and they can't hold you, and you can move on with your life. It's fine. Have I ever watched Suits? I have watched Suits, and I hate it. I hate it with a passion. And I hate it with a passion right from episode 1. And I have a personal grievance. I have a professional grievance against the show. In episode 1, season 1, episode 1 of Suits, the new guy comes in the door. The new attorney comes in the door. And the partner says, I need you to file this patent application. Fuck you. You can't do that. You need a special license for that. I'm a patent attorney, but he's not. He can't file a patent application. You fuckwit. And if you're a senior partner, you should sure as fuck know that. He might be licensed by the state of New York, but he's not licensed by the USPTO. He can't file a patent application. What the fuck are you doing? He's not licensed for that. Fuck you. Fuck you, Suits. And then throughout the series, because I've seen clips of the show, throughout the series, they'll do intellectual property things in state court, including patent things. They'll do patent things. I remember one clip I saw, they're in some state court proceeding talking about invalidating a patent. You can't fucking do that. You have to go to federal court for that bullshit. That's federal court, not state, you fuckwits. You can't do that. Also, they're very unethical. And they have massive ethics problems. So there's that too. I'm going to invalidate this patent. No, the fuck you're not. Do you know what a marksman hearing is? What's marksman? Okay, yeah. Let's go back to how much I like the logo. Let's go back to how much I like the logo on my microphone. Let's go back to how much I enjoy this brand new mic plate that I have. This is a nice mic plate. Isn't it great? I love it, and you should too. This is fantastic. It's a fantastic mic plate, and I love it. Let's go back to that. It was happier times. Oh, man. What else can I answer for you? Oh, yeah. So upcoming videos. Let's see. You guys saw the Logan Paul one already today. So I think today is the one dealing... Well, let me check my own schedule. What am I releasing today? Hypothetically, I'm supposed to release it in 3 hours, too. I'm releasing one relating to the city, the Dalton mayor, super mayor thing, and their chief of police with the indictment of the bankruptcy. Okay. So what? Yeah. So that's good. And then tomorrow, so that's today. Tomorrow is Matthew Perry and his death and the people getting indicted for that. And then the day following that is probably going to be Disney wrongful death, that case. That's got in the news. And the day following that is going to be the one I'm working on today, the Harvard thing. So at the moment, I'm 3 days ahead on my queue. Neat. New York also requires non-resident attorneys to keep an office in the state. Well, I'll get around that problem. I'll figure it out. Yeah, I'll figure it out. All right, guys, I guess that's going to go ahead and conclude our stream for today. Do you need a special license to do appeals? In state court, no. In federal court, technically, yes. It's one of the things that kind of like is bizarre, and I don't quite understand it. In every state, when you're licensed by the state, you're licensed in every court in the state, because that makes sense, right? So when I was sworn in Virginia, I was sworn in by the Virginia Supreme Court. I went to a ceremony. The Virginia Supreme Court was literally there. They had me raise my hand along with, 300 of my new closest friends. We took the oath. I was therefore admitted into every state in Virginia, every court in Virginia. Huzzah. When I was admitted in Texas, same kind of thing. I didn't do it in person this time. I did it by, a notary, because Texas law allows for that, but whatever. So I did it, and I was instantly licensed in every single court of Texas. Huzzah. But the federal courts don't do that. You have to be licensed in every single one individually, and there's 94 of them. Those, apologize. There's 94 district courts, 13 court of appeals, and the U.S. Supreme Court. So 94 plus 13 plus 1. And you have to get a license for each of them. And so that's a pain in the ass. So yes, I'm licensed by the U.S. Supreme Court, but unlike in the state law equivalent, that doesn't instantly license me in every federal court, which I think is annoying and stupid, but that's the law. So what can you do? What can you do? What can you do? It's just, whatever. Thank you for saying you love Thunderdome as well. I love Thunderdome. It's nice. Also, just is a weird quirk, the U.S. Supreme Court doesn't give you a bar number, which I don't know if it's the only court that doesn't do that, but it's odd. And also, they don't give you a card, which is also annoying. When I became a member of the Virginia Supreme Court, they gave me a bar card, which was literally a piece of paper that I had to have laminated myself, but still, And Texas, at least, they put some effort into it. They gave me a card that's like a credit card. It's a gold looking card that looks a lot like a credit card, and that was nice. And both states gave me a bar number. Both states gave me a bar number, but the U.S. Supreme Court doesn't give you either a card or a bar number, and that sounds like some bullshit. So I and also for that matter, the U.S. Court of Appeals for the Federal Circuit, where I'm licensed, also didn't give me a bar number. So maybe the federal courts just don't do the bar number thing. At least the two that I'm a member of didn't give me a bar number. So okay. Aren't there other specialty federal courts? There's the Court of Appeal. The only specialty court, well, there's the military courts. So those are technically federal. And then there is, of course, the Court of Appeals for the Federal Circuit that hears all the patent cases and also hears all federal claims. And of course, there's bankruptcy courts. There's the specialty courts for the bankruptcy. And I think those are all the specialty courts. So, yeah. None of the federal courts you're meant to gave you a bar number? I know. So apparently the feds don't do that. They don't give you a bar. They didn't. The Court of Appeals for Federal Circuit also didn't give me a bar card. This is some bullshit. Tax court? I'm not sure how licensing for tax court works. I don't know. You've got me. You've got me. Although, I don't think you have to be separately licensed for the bankruptcy court. I don't think you have to be licensed separately for bankruptcy court. I think if you're licensed for the district court, you're also licensed for the bankruptcy court, I think. But if that's not true, if you also have to be licensed separately for the bankruptcy court, then I need to add another 94 plus. Yeah, this could get annoying. Yeah. How do I keep track of the two numbers? Memorize them. My Texas number is 24 133 133, and my Virginia number is my Virginia number is, I don't remember. 73,000 something, 157. FISA. I'm not sure FISA requires a special license either. I'm not sure FISA requires a special license either. But the only people that go to FISA are the federal government. Because all FISA does is issue warrants. They don't do trials. So the only people that really go to FISA is the U.S. government, generally speaking. So, yeah. Yeah, I think, that's what I thought. The bankruptcy courts are under the district court. That's what I thought. MG law, that's what I thought. Yeah, the bankruptcy courts are under the district. So I thought it came along for the ride for free. That's what I thought. So, yeah. I know it's public, but don't dox yourself. Okay. Well, in any event, I'm going to sign off. I've enjoyed the stream. I hope you've enjoyed the stream too. I've been Uncivil Law. Until later, my friends. I hope all's well. Take care for now, my friends, and goodbye.